This video is part of a series intended to help citizens, members of the media, public officials, or anyone acting on their behalf to better understand Florida's exceedingly broad Public Records Act. These videos may be used by anyone and may be freely distributed without charge. I am not an attorney. I am not qualified, nor am I authorized to give legal advice to the public, so I don't. Any information provided by me in person, on video, or through fogwatch.org is readily available from the Florida First Amendment Foundation and the Florida Attorney General's Office of Open Government, as well as many other sources online. In 1984, a newspaper reporter for the Tribune Company sought access to the personnel files of 3 Tampa police officers that were involved with a shooting and death of a suspect. The Tampa Police Department imposed a 7-day automatic delay, purportedly to allow those 3 police officers time to review their own personnel files. On appeal, the Florida Supreme Court held that no automatic delay is permitted, that the sole purpose of custodial supervision is to protect the records from alteration, damage, or destruction, that the only delay contemplated by the Public Records Act is the time necessary to retrieve a record and review and excise exempt information. An automatic delay, no matter how short, impermissibly interferes with the public's right, restrained only by the physical problems involved in retrieving the records and protecting them. That the legislature has placed the books on the table, only it has the power to alter that situation, and that the only delay permitted by the Act is the limited, reasonable amount of time allowed the custodian to retrieve the records and delete those portions of the record the custodian asserts are exempt. In 1985, a local radio station, WMNF-FM, filed suit to compel the Tampa Police Department to allow access to certain public records. The Tampa Police Department asserted that the records were exempt from disclosure pursuant to specific statutory exemptions relating to an ongoing criminal investigation. The radio station demanded an in-camera inspection of the records, whereupon the court determined that in fact some records were exempt, while other records were not exempt. The court ordered that the non-exempt records be disgorged. On appeal, the Second DCA found that the legislative objective underlying the creation of Chapter 119 was to ensure that the people of Florida have the right freely to gain access to governmental records. The purpose of such inquiry is immaterial. The court further opined the breadth of such right is virtually unfettered, save for the statutory exemptions designed to achieve a balance between an informed public and the ability of the government to maintain secrecy in the public interest. The exclusive technique adopted by the legislature for the accomplishment of the Act's purposes is judicial intervention. In 1985, when Leroy Douglas sought access to personnel files in the custody of the Monroe Regional Medical Center, Dyer Michelle, the hospital's administrator, denied access. Subsequently, Michelle sought judicial intervention to prevent the disclosure of the personnel files. The Florida Supreme Court found that what is kept in personnel files is largely a matter of judgment of the employer, but whatever is so kept is public record and subject to being published. In 1985, the state attorney of Palm Beach County refused to allow the media access to certain public records. The state attorney argued that because those records related to an ongoing prosecution, they were exempt from disclosure. The records, however, had been made available to the defense through discovery. The Fourth DCA held that the Public Records Act is to be liberally construed in favor of open government to the extent possible in order to preserve our basic freedom without undermining significant governmental functions such as crime detection and prosecution. In 1985, the Florida Supreme Court addressed and answered the following question: Does the lawyer-client privilege section of the Florida Evidence Code exempt from the disclosure requirements of the Public Records Act written communications between a lawyer and his public entity client. The High Court's conclusion was a qualified no. The lawyer-client privilege section of Chapter 90 does not exempt written communication between lawyers and governmental clients from disclosure as public records, but Section 119.07, Parent 3, Parent O, does provide a limited exception within its terms. In 1986, Ernest Lee Miller and William Riley Gent filed an appeal for their convictions for murder. During their appeal, they sought access to certain public records within the custody of the Pasco County Sheriff. The sheriff denied access and filed an action for declaratory relief, seeking clarification as to whether or not he was required by the Public Records Act to disclose the records. The second DCA held that whatever information is discoverable becomes a public record when released to arrested persons, defendants, or their counsel. In 1987, a circuit court found, in a decision that was subsequently upheld by the second DCA, that the custodian of a public record may not make, as a condition of access, a requirement that the requester put his or her request in writing. Specifically, the court opined, refusal to comply with the request for inspection or copying cannot be justified on the grounds that the requesting party has refused to complete or furnish information for the completion of such a form. To hold otherwise would allow the custodian of records to engraft his own conditions on an unconditional right granted by the legislature. In 1989, the Miami Association of Firefighters and one of its officers, William Bryson, filed suit seeking a permanent injunction to prevent the City of Miami from future violations of the Public Records Act. The trial court granted the injunction, and the City of Miami and its Director of Internal Audits, Hattie Daniels, appealed. While the third DCA reversed the trial court's issuance of the permanent injunction, it did hold that impermissible withholding of documents otherwise required to be disclosed constitutes in and of itself irreparable injury to the person making the public records request. Since the purpose of Chapter 119 is to afford disclosure of information without delay to any member of the public, non-disclosure prevents access to the information and is an injury not ordinarily compensable in damages.